Former Alameda Research CEO Caroline Ellison is expected to be the next witness to testify in the SBF trial. Joining us now is partner at law firm Lowenstein Sandler, Rachel Maimin. Welcome, Rachel.
Thank you so much for having me.
Thank you for being here. So you were a former federal prosecutor at the Southern District of New York. You're now specializing in white-collar criminal defense. In the opening arguments, we have the defense trying to pin some of the blame here on Caroline Ellison, if not a lot of the blame on her. They claim that she did not do this. She did not do the proper safeguards. What do you think the jurors need to hear? How do you think this will play out?
So this is a very classic defense move by defense counsel, which is to discredit the cooperators, and she is arguably the government's most important cooperator. So what they're going to want to get out is any evidence of her lying, saying one thing to one person and one thing to another, saying different things than what she said previously, perhaps during her guilty plea or during her many, many meetings with the government, various ways to undermine her credibility.
So Gary Wong, last week he testified that Sam Bankman-Fried was the ultimate decision maker in the big decisions here in the process of trades, etc. His testimony, did you find it compelling at all?
Yes, I mean, I found it compelling, but like anyone, especially the jurors and others who have watched trials like this, obviously reserving judgment to see what happens. You can expect that someone in Wong's position who has pled guilty pursuant to a cooperation agreement with the government and whose ongoing cooperation and substantial assistance is going to affect what sentence he has, his testimony may be affected by that.
Hi, Rachel. The big question for many is, will Sam himself take the stand? Do you think he should?
I have a slightly unorthodox view on those things when it comes to criminal trials. In my experience, I have found that jurors find criminal defendants very compelling when they testify. It's very humanizing. It's very difficult if all you see are a person's text messages and hear about things they're saying. You don't really get to see them as a human being. And even if the cross-examination of Mr. Bankman-Fried were to be brutal, and I expect that it would be brutal by the government, at least the jury would have an opportunity to see him as a human being.
But looking at his text messages and, in fact, a barrage of information that he's sort of divulged to the world, while he's been in captivity, actually, what's your takeaway from that in terms of what type of witness he's likely to be?
Well, I would have some concerns on the part, if I were defense counsel, on his ability to follow instruction. He would have to be prepared very carefully by defense counsel, but it's very unlikely that his lawyers sanctioned any of the disclosures or other things that happened in this case that ultimately led to him being detained. And so there is a possibility that he is someone who would likely to go rogue, and you don't want to have a train wreck on the stand. It's better to just remain silent.
As we discussed earlier with our colleague Nick Day, this is primarily a case of fraud. That's clear and simple, and it looks like the prosecution is saying the technicalities of crypto don't matter here. How about the regulation of crypto, or the lack thereof, the lack of clarity? Does that have any play here? The prosecution says no, it doesn't. Is that something the defense can use and say, look, this is still unregulated. We don't know who's in charge. What did Sam really do wrong? Did he violate an actual statute regarding crypto? No. Does that fly, or is this a very clear cut? Are they going down the wrong path if they try to do that?
Well, I don't know that the judge would permit them to introduce evidence of whether or not he's broken any regulations or anything along those lines. I think that type of evidence could be relevant to the extent that it shows his state of mind, and that he didn't have a guilty state of mind because he thought he was doing right. But the judge isn't going to let there be, and the evidentiary rules don't let there be, a sideshow about what the law was or wasn't. The judge will instruct the jury on what the law is that's relevant at the end of the trial.
Rachel, prosecutors want Bankman-Fried to be banned from bringing up his investment in AI startup Anthropic as part of the defense. There's talk, of course, that this could be a very successful investment and the FTX creditors could be made whole as a result of it. And I think the DOJ believe that could be misleading in terms of its impact on the interpretation. What are your thoughts on that?
Well, it's a question of relevance. So evidence has to be relevant and not unduly prejudicial. What is the relevance to whether or not the investors could be made whole in connection with the question that is before the jury, which is whether or not these crimes were committed? Question of whether or not restitution can be made, that's really a sentencing question. It's a question that may be relevant to his sentence itself, but it's not necessarily relevant to whether or not he actually committed the crimes.
All righty. Well, thank you, Rachel. That was partner at Lowenstein Sandler, Rachel Maimin.